if I can first of all welcome everybody formally again. This is number 3 of 8 of our webinar series, the MLS Webinar Series. Tonight's subject is junctions, those dreaded junctions, which are our #1 accident spot. It's the highest number or percentage of cases that we deal with are those that have taken place at junctions. And Thomas is going to cover this in some detail, both using case studies and also some case law. This is Thomas. You've seen him on the screen here. Thomas is one of our solicitors, and I'm delighted to have him on tonight. So thanks for joining us, Thomas. I'll hand over to you. I'm actually doing his slides, so it's a double act here. So whilst I'm pulling up his slides, perhaps you can introduce yourself, Thomas.
Yes, of course. Thank you very much, Rod. Delighted to be here this evening, ladies and gentlemen, boys and girls, cats and dogs, beaming live into your living rooms. It is wonderful we're able to do this, actually. I know a lot of us have become very adept at using Zoom and other things like that over the lockdown. So it is a wonderful opportunity to be given to have a chat with you all. As Rod said, I'll be talking about motorcycling collisions at junctions. Now, my talk will involve some case studies, so cases which we've dealt with in the past, but also we'll look at a bit of case law, so other cases which have actually gone to court and been decided by judges. So before I get going on that, I think it's probably only right that I talk a little bit about, for those that don't know, who we are, whom I work for. So I am a solicitor at Motorcycle Law Scotland. Established in 2011, Motorcycle Law Scotland was set up by Brenda, who you can see there in the red, looking very dashing in red. She wanted ultimately to provide unrivaled legal representation for injured motorcyclists. We're very passionate about what we do here. We want to provide the best possible service to our clients. That's what we're all about. We believe Motorcycle Law Scotland is the first and only legal service in Scotland offering motorcyclists with purely motorcycling related legal advice and representation. We're by bikers for bikers. Following any type of motorcycle incident, it's always very important to try and seek as good a legal advice as you can, preferably from an expert in motorcycle accident law, and that's exactly what we are. So up there on the slide, you can see just a few members of our team. This is not the whole team, but just a small amount of us. You can see up there, Brenda's already mentioned, and Rod, whom is very helpfully doing my slides. Both Brenda and Rod are members of the Borders Group of Advanced Motorcyclists, don't you know? Andrew there in the middle in blue, he is our top administrator, and he basically helps the firm run administratively. He rides his motorcycle to work every day, and I'm including the days when it's snowing. So Andrew's a dedicated motorcyclist. As are Rod and Brenda. Ewan, who you can also see in the picture, has made several trips out to Europe in his time with pals, and he often enjoys trips up to the Highlands. But I suppose I should also mention a wee bit about myself, for those of you that don't know me. I'm a solicitor in Motorcycle Law Scotland's team. In terms of my motorcycling experience, I first passed my CBT, I think, when I was 17. And when I went up to do my law degree at Aberdeen University, the way I got around was on this ancient old clapped out Honda scooter. And having my CBT was very helpful because the flat I was living in was a few miles away from the university campus. So I used to zip up and down between university and home quite regularly. But on day 4 of week 1 in Aberdeen, that scooter was stolen. And I got a call from a PC so-and-so when I was in the middle of one of my first lectures telling me, you better come get your scooter, we've recovered it, but it's missing its front end. So that was the end of that for a little while and my motorcycling experience. Eventually got the scooter repaired and proceeded to enjoy it as much as I could around Aberdeen for the preceding 4 years that I spent up there. And I came back to Edinburgh to finish off my legal training and was lucky enough to be offered a traineeship with Motorcycle Law Scotland. When I did my traineeship, I was exposed to a lot of different types of cases. A traineeship, for those that don't know, is effectively on-the-job training if you want to become a lawyer. And it's 2 years worth of getting involved in cases and kind of learning at the foot of more experienced solicitors. So the cases I was kind of exposed to were things like road defect cases, complex injury, amputations, and also a few fatal cases. When you're trying as best you can to support the loved ones, people who have lost somebody as a result of a motorcycling collision. So the work is very varied, but it's also very rewarding. I mean, I won't lie, there are lows in the job because you're coming into a client's life when they're at the lowest possible point they can be. You know, they've been involved in what can sometimes be a catastrophic, life-changing incident. And your job ultimately is to try and leave that person in a better position than when you found them. And that is really our raison d'etre at Motorcycle Law Scotland. We're there to ultimately support our clients as best we can. As far as the rest of my motorcycling experience, I did pass my direct access eventually, moving on from my CBT in 2018. I am a member of the Institute of Advanced Motorists as a driver, and I passed with a first qualification in that, which I was quite pleased with. I'm currently on the hunt for a motorcycle of my own, but we'll see, depending what my wife says. Hopefully we'll have something by summer, but you never know. Needs must. So, as well as obviously being a firm which has values steeped in providing the best client care, in order to do that, we need to be around Scotland. It's no good just being in one location. A lot of the times you'll see firms are centrally located in either Edinburgh and Glasgow, but the team at Motorcycle Law Scotland, we're set up ultimately to serve our clients from our offices across the length and breadth of the country. So you can see there up on the map, we've got offices as well as Edinburgh and Glasgow. We have an office in Aberdeen and an office in Peebles for our borders clients, which is where I am reporting live from tonight. A couple of tools of the trade, if you like. These are often used by lawyers when it comes to looking at how to progress a motorcycle case. You don't see them too often with your run-of-the-mill personal injury solicitors because they might not know they exist. These are what we call our Bibles. When you're dealing with motorcycle incidents, you're often looking at matters such as who's at fault. And these books can often be very helpful in determining exactly why a motorcyclist might have done something and looking at things from their perspective. The Highway Code is used not enough, in my view, when it comes to legal pleadings, because ultimately the Highway Code kind of dictates the rules by which we should really be driving our motor vehicles. And it always is very helpful in providing guidance when it comes to assessing fault. That said, things are obviously unique to a case or any one case. It's individual factual circumstances, but these little tools of the trade are very helpful little tidbits you can kind of pick up and use as part of advancing your own client's claims. We see the common motorcycling incidences at, just up on the slide there, those are the most common. My colleagues will be talking about some of these in the other talks, which I believe are ongoing throughout this week and will continue to do so. Obviously, the one I'm going to be talking about tonight is the bottom right there, Junctions. But I would encourage you, if you've not already signed up, to have a look at the other talks we will be doing. Now, I'll show you some video footage, just a bit of a warning. These videos show motorcycle collisions. So if you are squeamish at all, then you're welcome to perhaps look away. They don't actually show any catastrophic injuries occurring, but they can be for quite compelling viewing. So I'll let you go through these videos with Rod, and then we'll come and look at some case studies.
The first one's all right. He avoids the collision, Thomas, but here we go. I need to look at the right-hand side of your screen here. This is not a great video, but look out for the Harley heading towards the hashed area and some vehicle putting across its path. Vehicle being a bus. This was down south. It just shows how easy these things can happen at junctions or traffic lights. And this was actually in South Africa, but it represents another classic scenario of somebody who was taken out at a junction.
Right. So obviously the number one takeaway from that, I suppose, in those videos is these things can happen so quickly. And a lot of the time, being a motorcyclist, you have to ride defensively. We all know that. We're one of the smaller vehicles on the road, and we're very vulnerable because we don't have 2 tons of metal around us. So even if you're the best motorcyclist in the world, sometimes something might come up that's unaccountable. So I think the videos just demonstrate that and how quickly these things can happen. There was a gentleman by the name of John McDonald, who is one of the most well-renowned motorcycle trainers in Scotland. And he's a highly skilled motorcyclist, but his number one tip was to always avoid anything which is larger than you, whether you have right of way or not, which I always think is quite a helpful tip to have in your mind. Now, moving on to these case studies, I'm very grateful for the clients whom have allowed us to talk about these cases because they are real life cases. And they're a bit of a peek behind the curtain for all of you guys because these are cases which didn't make it to court, but they are from real clients that we represented, and the scenarios are obviously demonstrative of how these things can get worked out. Now, up there on the slide, you can see there is an entrance to a garden centre called Scott's. Now, if Rod puts a cursor over that particular entrance, now the first one there, Scott's, there we go. Now, this case involved a gentleman by the name of Hugh. And Hugh, unfortunately, is a repeating client for us. He's been involved in a few incidences, none of which are primarily his fault, I should add. I think he's just been rather unfortunate. But this particular case happened around about summer 2018. And at the time, Hugh was riding his BMW R1200R, which is a big upright bike, for those that don't know, headlight illuminated, along the A73, which is the Lanark Road. That's the road in the picture. Now, Hugh's direction of travel would be away from us as we look at the picture. He was established on the road, great big long section of road, riding at about 40 miles per hour, which is the speed limit for that particular road. And there was a vehicle waiting here at the entrance to Scott's Garden Centre. So who has right of way there? Hugh does, of course. So what happens? Well, this particular vehicle pulls out of Scott's Garden Centre and it pulls onto the roadway, same direction as Hugh is travelling. The vehicle, curiously, doesn't accelerate up to 40 miles per hour or anywhere near 40 miles per hour. They are crawling along, and I mean crawling. They're obviously looking for something. And it turns out they were looking for the entrance to the other garden centre, which you can see at the far end of the picture. They'd pulled into Scott's initially, and Scott's was closed, so they thought, oh, damn, we'll go next door. So off they go. They're going next door. Hugh doesn't know this. So Hugh, as he's riding along, thinks, oh my goodness, what's this person doing? And the road surface at the time was damp. It's worth bearing that in mind. So Hugh takes all of this into account. He sees the vehicle pull out. He sees that it's not traveling up to the kind of speed he would expect. So he makes a logical decision to go past the vehicle. Instead of subject himself to what could have been an emergency stop maneuver, he decides he'll just pass the vehicle, no problem, just head on by. Hugh makes all of this assessment in split seconds, carries out his lifesaver, goes to go past the vehicle. As he's passing that vehicle, it turns right into his path. Poor Hugh wallops into the vehicle, and I believe he suffered a fracture to his ulna and soft tissue injuries to both of his shoulders, so not insignificant injuries. Now, the police were called to this particular incident, and rather unfortunately, to add insult to Hugh's injury, 4 days after the police had initially arrived and things had settled down, they decided to charge poor Hugh. And they charged him with Section 3, which is careless driving. Now, forgive me if I'm wrong, but nothing I described in relation to anything I mentioned before about the incident circumstances struck me as careless. So I don't know what necessarily might have gone through the arresting of, well, not the arresting officer, but the charging officer's mind, or indeed the procurator fiscal's mind, who actually proceeded with this case to a criminal trial. And I went to the criminal trial and I sat there listening at Lanarkshire Sheriff Court. And it was actually a Justice of the Peace Court that was heard in. And although Hugh was very ably represented, they found him guilty of careless driving. There was CCTV evidence which showed that the vehicle which had pulled out of Scott's and driven along the road had done what was in effect an elongated U-turn. They're literally coming out of one junction and heading into another. There was no evidence whatsoever that Hugh was traveling in excess of the speed limit or anything that would possibly put a contribution of liability on his part. What he did was ultimately reasonable. In my view, the finding of guilt was a miscarriage of justice. I can't describe it as anything else. It was utterly appalling, and I don't, I'm not going to pull any punches when I use that word. It was appalling. At the end of the day, sometimes the difficulty with justice of the peace courts is that you have individuals, lay people who are sitting with a legal advisor. And whilst generally as an institution, a justice of the peace court, you're judged by your peers, sometimes you can get outcomes like this, where you don't have a professional person who is legally trained actually making a decision. But despite the finding of guilt on Hugh's part, that did not deter us. We knew that where the criminal courts had failed, the civil courts would succeed and justice would still be available to him. Whilst Hugh had justice denied in the criminal courts, that would not happen in the civil courts, and we were very determined to ensure that would not happen. So we fought tooth and nail for Hugh, and eventually, after a number of offers from the insurers of the vehicle, which turned right in front of him, we got to a point where the defenders were ultimately beaten into submission as a result of evidence that was gathered. I recognized the reporting officer myself, and I honestly could not tell you why he had made the decision he had made based on the evidence he had gathered. And to tell you the truth, neither could he. And he couldn't do that in the criminal trial, but despite that, there was still a finding of guilt. So at the end of the day, Hugh was eventually awarded a very reasonable settlement of his claim. And it just shows you that even when there is a finding of criminal guilt against you, it does not preclude you from seeking redress in the civil courts, because these things are assessed on a different burden of proof ultimately. The next case, which if Rod would do the next slide, we can move on to. You there, Rod?
Yeah, I am here. Hold on a second. It wasn't moving on for some reason. Hold on, we'll get there. There we go.
Perfect.
Sorry about that.
No problem. This case involved a very experienced motorcyclist. He was riding a Kawasaki ZZR 1100 at the time. Now, those of you who are local to the Edinburgh area may recognise that this is Stenhouse Road. It's near to the prison, and you can see that it is a 4-lane undivided carriageway, with 2 lanes being dedicated to buses. Now, of course, motorcyclists can use bus lanes. So Jethro was on his way home from work, which is a very well-known motorcycle dealership, which is just further on down the road. Traffic in both of the lanes, which are not for buses, was travelling very slowly. It was stop-start. This is kind of the major route to get out of Edinburgh if you're heading onto the city bypass, so it always clogs up around about its rush hour. So one of the virtues, of course, as we all know, of being a motorcyclist is that you can nip through traffic if you want to. So that's what Jethro was doing, but he wasn't flying along. He was positioned in that bus lane at a kind of a central position in the lane, and he was traveling at 25 miles an hour. Now, Jethro has had a motorcycle license since 1999, so he knows what he's doing. And he was keeping a constant eye to his right-hand side to see if any vehicles would be coming through the gap or if any chancers thought they could, fly up the bus lane. And just as Jethro gets to the point where that junction is, you can see on the slide just beyond where the lamppost is, a vehicle which had been traveling in the opposite direction turned right across his path. There was absolutely nothing Jethro could do to avoid the collision. It was similar to some of the videos we've seen, something that happens like that, snap, bang, nothing he could have done. Jethro suffered quite significant injuries. He suffered an unstable fracture to his T12 vertebrae, and a number of other vertebrae were also damaged. So he required actually fusion of his vertebra. And this case is rather odd because a pre-medical offer was made. Now, pre-medical offers are nasty little things, or they can be. They're often adopted by insurers who wish to try and buy off the risk of a case. And the difficulty for any legal representative, whether it's a lawyer or otherwise, is telling you the valuation of your claim without medical evidence. It's not completely unheard of, but sometimes it can happen. And you can take a view based on medical records, but ultimately what you're always needing 9 times out of 10 is an independent report from somebody like an orthopedic surgeon or a neurosurgeon, depending on the type of injury to the client. With Jethro's case, there was an early pre-medical offer made by the particular insurer involved, who are well known for making pre-medical offers. And happily, in Jethro's case, it represented what could be described on one view as an overcompensation of him. But at the end of the day, having taken Jethro's instructions on the offer and advising him that we couldn't possibly tell him a true valuation of his claim, but that the pre-medical offer did possibly represent an overcompensation, he was happy to accept that offer. So this case is one that demonstrates, number one, the client is always the master. Your case is your own. So whilst we can give you legal advice, at the end of the day, you're always in the driving seat, and you can choose what to do with your own claim based on what we're dealing with. Secondly, it shows you how quickly a situation can develop. And thirdly, it also shows the kind of nuanced offers you might receive in a certain type of incident, such as a junction collision, because they're so common and because liability is often a bit of a forked issue. Now, the third and final case study that I'll talk about tonight is a case of my own, which I dealt with. This particular one was quite interesting because it represented a bit of a split in terms of who was at fault. A formal agreement regarding fault in this particular case, but the case settled for what was a compromised agreement, but it was quite a good compromised agreement based on the evidence. Now, this case involved a gentleman called Charles. Now, Charles was an IAM trained motorcyclist of significant experience, so he certainly knows what he's doing when it comes to handling a motorcycle. He was riding south on the A76, so he's heading away from us. Great big long stretch of road. It's a lovely day. He's out with his friend who's behind him, and they approach a group of vehicles around about this location. They're traveling slowly. There are 3 or 4 vehicles in the particular line, and they're going at a speed around about 40 to 45 miles per hour. Now, Charles can see that this is a great big long stretch of road. He can see for about a mile ahead of himself. So he carries out his IPSCA observations: information, position, speed, gear, acceleration. That is the advanced motorcycle training for when you approach any type of situation. Gives a lifesaver, heads out into the northbound carriageway. Makes his way past 1 vehicle, fine. 2 vehicles, fine. The 3rd vehicle makes a turn right into that junction that you can see, which is demarked by the white sign. That's the Lockside Hotel and Lodges and Spa. Now, there were evidence from witnesses who were following the vehicle which turned right in that queue which Charles had been overtaking that said that the vehicle driver was indicating. Now, there was evidence from Charles himself, he didn't see an indication. And there was also evidence from his friend Peter that he didn't see an indication either. But ultimately, you are dealing with independent witnesses who had no connection to that driver who said that there was an indication. So this case demonstrates that sometimes there can be difficulties in relation to evidence, particularly when it comes to witness testimony and something as crucial as an indication. Now, liability was always going to be denied on the part of the insurer, so proceedings had to be raised in court in this particular case. We worked very carefully on the wording of Charles's written case, because whilst there was evidence that there may have been an indication, ultimately what we had to say was that Charles had been established in that northbound carriageway. There's no way, if the driver of that vehicle had made a check in their side view mirror before turning right, they would not have seen him. He was there to be seen. So we were able to successfully argue that the cause of the accident wasn't necessarily Charles overtaking at a point where it was inappropriate to do so. It was more to do with the fact that this driver hadn't adequately made their checks prior to turning right, because if they had, they would have seen him. Now, there was a deduction for what's known as contributory negligence on the part of Charles. And the reasons for that are several-fold. Number one, he overtook where there's clearly a junction. As an IAM rider, you should have seen that. And it's very difficult to get around that. Particularly sometimes when you are an IAM trained motorcyclist, or ROSPA is the other one, it can work against you in terms of your legal case if you've done something which is a little bit naughty. Now, we're all motorcyclists at the end of the day. I'm not going to pretend that we all go around below the speed limit all the time. I mean, of course, we're safe and considerate riders, but when you see a group of cars, you know you're going over 60 on an A road, possibly, if you have to overtake them, because you have to get in and out as quick as possible. But equally as well, you also have to take extreme care when approaching anything that looks like a junction, and you have to also assess the road conditions. But that's just demonstrative that sometimes these matters aren't quite as clear-cut and black and white as you might think. Now, moving on to some case law. Case law is great because what previous cases give us as lawyers and you, the client, is somewhat of certainty about what can happen if this kind of thing happens to you. Now, case law makes up what's known as the common law. And this is law handed down by judges throughout the years, hundreds of years, actually. And it represents what happens in certain situations. All they are is really stories. Case law are stories of people like you and me being involved in sometimes awful things, sometimes good things, depending on what the case is about. But they give us a little bit of an idea as to how a similar case might be decided so that we can give you advice. Now, this particular case, Hernandez v. Acar, is quite an interesting one, and it's being talked about an awful lot at the moment in legal circles. I don't know if any of you saw my Scotsman article. I highly recommend you read that. I talked a little bit about this case, but I'll give a bit of an overview for you tonight. So around about 2014, I think it was, in the summer, a crash occurred at this particular junction you can see up on the slide. Now, Acar was riding a BMW motorcycle. It was a BMW R80. Now, those of you who remember when the R80 was brought out, it was originally an adventure touring bike, but nowadays they're more popularly converted to kind of cafe racers and scramblers. I'd really like one myself, but unfortunately funds permit me from getting one at the moment. Never mind. Now, there was also a BMW motor vehicle parked at this particular junction. Well, they weren't parked, they were waiting. Now, what happened was Acar was riding his motorcycle kind of away from the photo as we look at it. And when he came to this junction, what happened was the driver of the BMW vehicle pulled out into the road. Now, this Google image doesn't quite show the same amount of parked cars that were there the day of this particular incident, but you can see kind of towards where the junction, the giveaway lines of the junction are. If you look left towards the end of the picture, there's another car parking space. There was a vehicle parked in there too. So you can imagine chock-a-block in London as you'd expect. The BMW vehicle pulls out. Acar strikes the front offside wing of that BMW motor vehicle. He's unseated and thrown 12 to 30 meters forward, and his motorcycle collides with the rear bumper of another parked car, which is on that Victoria Park Road, which is the main road you can see in the photo. Now, the injuries sustained by Mr. Hernandez, I should say, was riding a motorcycle, not Mr. Acar. They were life-threatening. He was rendered a paraplegic as a result of this collision. So a very significant case in terms of how it would be decided would have a huge impact on his quality of life, possibly moving forward. Now, the evidence in this case was effectively that Hernandez had been riding at a speed of 50 miles per hour in a 30 mile per hour zone. So he was cracking on a bit. The driver had emerged from the junction when it wasn't safe to do so, which is contrary to Highway Code Rule 170. But ultimately, anyone can see that there is fault on both sides here, both the motorcyclist and the BMW driver. The BMW driver for emerging when it was unsafe to do so, but the motorcyclist for flying through a 30 mile an hour zone at 50 miles per hour. The case was very finely balanced when it came to who was to blame, because the issue of blameworthiness was very potent in this particular case. And my article in The Scotsman touched upon this. It's clear that both motorcyclist and driver were negligent. That much we can all see through our own common sense. But there was something known as causative potency, which came into the judge's thinking when it came to apportioning liability between the two parties. Now, causative potency is a recognition of who brings the most harm to an incident. And when you're a little itsy-bitsy motorcyclist, you don't bring as much harm to a collision as a large BMW. So the causative potency argument was used to tilt the balance back in favor of Mr. Hernandez, the motorcyclist, because ultimately it acknowledges that a motorcyclist is a vulnerable road user. And it reflects how courts protect the most vulnerable road users when apportioning liability. So in this particular case, despite the fact that he was traveling over 20 miles per hour beyond the limit, the motorcyclist was only 40% to blame, whereas the BMW driver was 60% to blame. It's a really interesting case and a really good example of modern judicial thinking when it comes to apportioning liability and recognition of vulnerable road users. It's actually a cracking case. The next one is a little bit older. And this was an appeal case. Apologies for those of you who might work in the legal profession. I'm using all English cases, but sorry. This was an appeal case to the highest court within the senior courts in England and Wales, with the exception, of course, of the Supreme Court. Now, the pursuer, or claimant as they're known in England, was riding a motorcycle. You can see there in the image, and he was initially behind this bus, which was turning left. Now, I don't know about you, but we've all been in a situation where there's a vehicle in front of us approaching a junction and it's turning into that junction. So what do? We overtake it. How many times have you done that in a car? How many times have you done it on a motorcycle? I know I've done it in a car a few times. But if you're waiting at that junction, waiting to turn right, as that car is in the photo, do you wait to see if something's coming? Should you wait? You're damn right you should wait, because there might be a motorcyclist masked by the vehicle which is coming in. And that's exactly what happened in this case. As the bus turned off the major road into the minor road, there was that vehicle waiting to turn out from the minor road onto the major road. And upon seeing the bus driver's signal and seeing the bus beginning to turn, at that moment is when the motorcyclist began the act of overtaking the bus on the offside. Common, happens all the time. Unfortunately, the bus masked the motorcyclist to the vehicle that was pulling out, and equally, neither party could see each other. So the first they knew of each other was when the collision occurred. Now, originally, when this case was first heard, the judge who heard the case dismissed the motorcyclist's action against the driver for negligence. Totally out of hand, dismissed it. Nope, you're off of your misfortune, go away. Very unsatisfactory decision. So there was an appeal. And on appeal, the decision was completely and utterly reversed. The appeal for the motorcyclist was allowed in full, and the finding was that the driver of the vehicle had been negligent by not waiting until he could see the major road was clear before pulling out onto it. Because ultimately, as was noted by the judge at the appeal, there might have been a vehicle behind that bus. So it does show you that sometimes, even when a case comes before a legal expert, they can get it wrong. Now, the next case of Hamilton v. Okane and another is also an appeal case because a judge had got it a little bit wrong the first time round. So this case is all about a judge who, when apportioning liability for a road traffic accident between the rider of a motorcycle and the driver of a car, with which it collided, causing serious injuries to the pillion passenger. On the evidence, the judge had found that they were both equally to blame for the accident. Now, just to give you a little bit of background here, Hamilton is the person who is pursuing the action. Now, they were the pillion passenger, and Okane and another. Okane was the rider of the motorcyclist, and another represents the driver who pulled out of that street you can see in the image. So when you're a pillion passenger, normally you tend to, or you might have legal advice to suggest, depending on the driving of the person whose bike you're on the back of, to raise an action against them and their insurers, because your injury might have been caused as a result of their riding instead of as a result of some kind of third party. So it's worth bearing in mind. Now, the judge, as I say, in first instance, found that the motorcycle driver and the vehicle that pulled out were both equally to blame for the injuries sustained to that pillion passenger. The motorcyclist wasn't happy with that finding, and they appealed against that decision, apportioning liability equally amongst him and the driver of the vehicle. There was evidence that the motorcycle driver had been over the drink-drive limit at the time of riding. The motorcycle, as I say, was traveling on that major road, that Leith Avenue, and they were involved in a collision with a vehicle moving out from that minor road. Now, the injuries to the pillion passenger were quite serious, but at trial, there was evidence that the motorcycle rider had been riding in the middle of the road, and that as they were riding in the middle of the road, the vehicle had emerged from that minor road. Now, there's also an independent witness in there that said that the motorcyclist had to swerve to avoid a parked car. It was never fully clear as to exactly why the swerving was going on, but ultimately the judge held that the motorcyclist, at first instance, certainly should not have been riding at all, and certainly shouldn't have been traveling at the speed he was, given the presence of parked cars. There's no parked cars in the particular image, but at the time there were lots. Now, when this case came to appeal, the appeal was allowed. Now, the finding was that in the circumstances, the speed at which the motorcyclist was traveling was not of any causative importance. So the speed was not a factor in determining how the accident actually occurred. There was also no evidence that speed had contributed to the accident at all. And there was also no evidence that the driving of the rider of the motorcycle had been impaired as a result of alcohol. So at the end of the day, there was no link between that act of riding a motorcycle while possibly being impaired and the accident occurring. Very important causative point. But they did say that the judge at first instance was right to say that both were to blame, both the motorcyclist and the driver who emerged from that minor road, but that the apportionment wasn't right. The judge had failed to take account of the fact that that driver had pulled out without looking. So he reversed the decision, and at the end of the day, there was a little bit of a difference in the finding of who was to blame for the injuries sustained to the pillion passenger. The thing to remember is that each case is individual and fact sensitive. You are an individual, so your case will be unique to you. Compensation is ultimately an effort to put right a wrong. If you've been unfortunate enough to have suffered harm as a result of an omission or act of somebody else, then the only measure that our society has to put that right is compensation. It's really restorative justice at its finest. But if these cases and case studies demonstrate anything, it's that the facts are absolutely crucial. And you really need legal representation that's going to ensure that everything that can possibly be dug up is dug up. And not only that, you're not going to be closeted from things that might possibly be damaging to your case. You need to meet problems head on, and that's what we do. We will advise in relation to the evidence. We will not try and craft a case in order to support one narrative or the other. At the end of the day, it's about justice and fighting for that. So what if it happens to you? Well, if you are unfortunate enough to be involved in a road traffic collision and you are able to, the most important thing to get is that third-party registration number, the person who possibly caused the accident. That's a crucial and key piece of information because it allows you to trace the insurer. Also, helpfully, everybody has a smartphone these days, so photos of the incident scene are always absolutely brilliant because witness testimony can sometimes be a little bit faded over time. And you can have 10 people witness the same incident and they'll all have a different opinion as to how it actually occurred. And photos are very difficult to argue with. So photos are always very helpful. If you are injured to the extent that you can get this information, then the police have a role and they step in. And after preservation of life, their role is really to gather information about the incident and collision circumstances. Now, we do offer a free legal advice service. These are some information cards which we produce, which are available. They just give information regarding what we can do, a lot of common motorcycle incidents, similarly to what myself and my colleagues have been talking about today. But at the end of the day, we always offer free advice service. We're motorcyclists just like you, so we're here for you. And this is a service which is underutilized, I think. So if you do ever have any questions about something that you think we might be able to assist with, just give us a call. It's free at the end of the day. We'd be delighted to discuss any query you have. Now, I think that's it from me. I've noticed a few questions coming in as I've been rambling on. So I think if Rod could pull those up, I'll be quite happy to answer them. If people want to shout out questions as well, I think Rod has the ability to kind of let you have kind of speaking privileges, and then I'll be able to answer those questions. So thanks very much, everybody.
Thank you, Thomas. That was really, really interesting. I mean, I've listened to an awful lot of presentations over the years, and that was particularly interesting and valuable. So thank you for that. Yeah, I think we've got about 8 questions, actually. So we'll have to whiz through these if we can. I mean, the first one was from John, who asked, does Hugh, I presume this is Hugh Johnson, does he still have a criminal conviction?
Yes, unfortunately, because he was found guilty, he does have that on his record, and he will have to disclose that to any insurer. As I say, that was an appalling miscarriage of justice. The person who represented Hugh is, as I say, a very able criminal solicitor, and even though he has been hardened by years battling it out in sheriff courts across the land, he honestly was bowled over by that particular decision. And at the end of the day, we're lawyers, we're practical people, and we work on the evidence, but even he couldn't believe the decision which was come to on the basis of the evidence we heard. So it was an appalling decision, and it will remain so, but I was pleased that he was able to get civil justice where the criminal system had obviously failed him.
Okay, thank you. Daryl's asking, if you break the speed limit to overtake somebody or a group of vehicles to ensure that you can get back in safely, are you allowed to do that? Is that legal, that you can actually go and overtake something beyond the speed limit just to get past vehicles that are in your way?
Strictly speaking, no. When you break the speed limit, you're breaking the speed limit. That's the long and short of it. On a practical note, though, at the end of the day, you have to ride within your limits and also so that you're safe. And if you're overtaking a group of vehicles and you're going to have to go beyond the speed limit to do that, then I wouldn't counsel against it. But equally, you do expose yourself to possibly being caught by a speed camera or otherwise. It's a mitigating factor, But at the end of the day, the speed limit is the speed limit. So you're not technically allowed to do it when you look at it from a legal standpoint, but from a practical safety standpoint, then there are occasions where, yes, the speed limit has to be broken. But I would never recommend it as a matter of course.
Okay, cool. Just moving on. Niall's asking for a link to your Scotsman article. Yeah, Niall, no problem. I'll ping that across to you, or I'll make it available for everybody. It was actually on the Motorcycle Law Facebook pages earlier this week, but I'll certainly get that to you. Ewan's asking, Thomas, does the decision of the English court actually automatically apply in the Scottish court?
The answer to that is no, it doesn't automatically apply, but it does provide helpful guidance. So whilst the precedent doesn't necessarily have to be strictly applied, you could quite easily cite this case if you were arguing a similar case to demonstrate your point. We take inspiration from all types of different legal jurisdictions, and obviously the closest one to us is that of England and Wales, but it isn't strictly applicable, but it does demonstrate some helpful ways in which that jurisdiction has dealt with that incident. So it is still helpful to cite those kind of cases, yes.
Okay. Carl's asking the question of pillions. He was obviously interested in the pillion case, and he says he pays for pillion insurance with his bike insurer, but nobody asks for passenger insurance on your car insurance. What are your thoughts on that?
Now, I've never come across pillion insurance in my life. Now, that doesn't mean to say that it's not something that's worthwhile having. I do not know the particular cover that a pillion policy would have. I can't necessarily comment on something which an individual insurer offers. It does tend to, when you're carrying a pillion passenger, you have to remember that you're obviously in control of the vehicle that that pillion is on. And as a vulnerable road user, you are exposing that person to a risk. So you have to be extra careful in the way in which you operate that machine. And if you don't operate that motorcycle with due care and attention and something happens, then of course that pillion has recourse to go against you. Now, I don't know if the particular insurance you have covers you for that. Whether it's a separate policy you have out with your own policy of insurance on the motorcycle. But it would depend on the individual insurer, I suppose.
Okay, thanks for that. Gavin was asking whether or not, something to do with overtaking at a junction. He says, I was of the belief that you weren't supposed to overtake at a junction. I guess this isn't the case. Well, you shouldn't be overtaking at a junction, but sometimes this junction jumped out and I don't think the guy was actually aware of it being there, or he'd forgotten. I think that was the issue.
Well, I mean, the Jordan case is quite interesting because, yeah, you're right, Gavin, you shouldn't overtake at a junction. It was more to demonstrate the fact that just because you do something which is perhaps something you shouldn't do, it doesn't necessarily preclude you from pursuing a claim. It comes back to the individual factual circumstances. And whilst Charles could be criticised for overtaking at a junction, he was still able to recover damages for his injuries because the main causative factor involved in the incident was the fact that he hadn't been seen when he was there to be seen. But the reasons why there was a deduction in relation to contributory negligence on his part was because he overtook at a junction when he shouldn't have. So, I mean, he really ultimately, if you are to criticize him, he should have seen that. But it could have been the situation where he received nothing because a judge might find that he was the author of his own misfortune by overtaking at that point. But it was just more demonstrative of the fact that each case is fact sensitive.
Okay. A couple more. Steve's asking, do you have to wait for your settlement before you get the other side to pay for your physio? And rehabilitation, I guess.
The answer to that is no. If you have an agreement with an insurer to fund rehabilitation, then they are obliged to do that. In fact, it's encouraged. So there could be matters involving you trying to go through that recovery process, and a decision cannot be made on what the settlement of your claim is going to be because you're still recovering. So in the interim, if we can work with an insurer and there's not an issue of liability, then the insurer is normally obliged to help fund private rehabilitation, whether that be physio or other treatments. So not necessarily, you don't have to wait. but it does depend on the case.
Okay. A couple more, and then we're there, I think. In the Hamilton Okane, in another case, someone is asking, how can factors like speed and possibly alcohol consumption be dismissed as contributing factors? Surely they are critical to what happened.
It does depend on, as I say, it comes down to the factual circumstances. Whilst they are important, they're not critical factors in how the accident occurred. And this is an important legal distinction. It's known as causation. So what is the causative factor which brought harm to the injured person? And the judicial thinking in the appeal was that the causative factor wasn't the speed, and it wasn't possibly being impaired by alcohol. It was that vehicle pulling out. So if you look at it this way, if that vehicle had never pulled out, the accident would not have happened. So they basically made an assessment on that basis, in that that was the major causative factor for the incident occurring, not the being impaired and not the speed. I mean, you could put an argument that if you've been traveling at 100 miles per hour, swerving all over the road, and that vehicle never moved out, accident doesn't happen. So the main causative factor was that vehicle pulling out from the minor road, and that wasn't factored into the original decision when the judge first apportioned liability between the two parties.
Great. Okay. A couple more. I think there are quite a few more, but we'll hopefully people are still happy to stay on, and we'll get these answered. They're obviously interesting questions. Interesting. Ewan, who has come from an insurance background, actually made a comment on the pillion issue, where he's basically saying it's an indemnity issue. So if you don't have pillion insurance and you do carry a pillion on your motorcycle, the insurer can argue you didn't have proper insurance. So it's like a modification. It increases risk potentially. And they could perhaps argue if you had an incident that your insurance wouldn't be validated. Effectively, it's an additional revenue stream for insurers. We've seen that before.
Don't be rude, Rod.
Okay, Rosie Robertson. If I was riding my bike and car turned into me from a major to a minor road, when the bus lane had just opened up in my favor, who is at fault, and do I have a percentage of blame? I think this will be fact sensitive. I guess we need to understand a bit more about that. But do you want to answer that, Thomas, or can you answer that?
Well, I'll give you a lawyer's answer, Rosie. The answer is it depends. It would depend on the factual circumstances surrounding the incident. When you're looking at apportionment of liability, it does come down to what the evidence shows. And ultimately, when you're looking at percentage settlements, there's no right or wrong. It is fact sensitive. So the answer, unfortunately, is it depends.
Okay. We've got another couple of comments on the pillion issue. I think what I'm going to probably do is deal with those. I think these are people who understand the insurance industry inside out and have got a comment there. So what I'm going to do is take some of that information and we'll put it out to everybody that attended here just for an update after this event, if that's okay. I think that's pretty much it, other than people saying they enjoyed your presentation, Thomas, which is great to hear, very pertinent and informative. So good. I'm glad everybody enjoyed it. If we can perhaps just leave it there, I'm going to thank Thomas clearly for a very informative presentation and for his time on a Thursday evening. I know you're still in the office. Hopefully you'll get back home okay on your bicycle and it's not too dark. And just to remind everybody that the next presentation a week today is Brenda Mitchell, who's going to be looking at filtering, that famous old filtering again, which is a perfectly legal act for motorcyclists to do, but not everybody understands it. And she's going to do that by actually looking back through the ages. So those of you who like old motorcycles, we're going to be taking a look at a lot of old motorcycles back in the day, a lot of nice pictures, which I'm going to have to gather from various different places. But this will be an intriguing presentation, none like you'll have seen before. All right. Thank you very much again for all of your time. Thanks for joining us, and good evening.